Legal language can feel like a maze of complex terms, but understanding a few essential concepts can help you navigate everything from contracts to courtrooms. We're going to break down some very basic and common legal terms. Plaintiff and defendant. In a legal case, the plaintiff is the person who initiates the lawsuit, while the defendant is the one being sued. For example, if A sues B over a contract dispute, A is the plaintiff and B is the defendant. 2. Burden of proof. The burden of proof is the obligation to prove one's assertion in a case. In criminal cases, so the state versus a particular person, the prosecution, the state bears the burden of proving the defendant's guilt beyond a reasonable doubt. In civil cases, the burden is usually by another standard, by a preponderance of the evidence, or on a balance of probabilities, who is more convincing. 3. Statute. A statute is a formal written law passed by a legislative body, such as Congress. For example, the Civil Rights Act of 1964 is a statute that prohibits discrimination based on race, color, religion, sex, or national origin. 4. Precedent. Basically, precedent is a previous court decision that guides future cases with similar circumstances. For example, if a high court rules on a privacy case, the lower court often applies the precedent in a future case involving similar privacy issues, just following the same thing we did last time. 5. Contract. A contract is a legally binding agreement between parties. There are different elements to a contract to make it enforceable, and a contract under the eyes of the law. We won't get into that here, but here you just need to know that, when you sign a lease for an agreement to an apartment, that lease is a contract outlining terms such as rent amounts, lease periods, and responsibilities. 6. Liability. Liability refers to legal responsibility. For instance, if someone slips and falls on a wet floor in a store, the store owner may have liability if the store owner failed to clean up or warn the customers of the hazard. This is in tort law. 7. Damages. Damages are monetary compensation awards to a party in a lawsuit for a loss or injury. For example, if a driver causes a car accident, they might be ordered to pay certain amounts of damages to the injured party for, say, medical expenses. Injunction. An injunction is a court order requiring someone to do or to refrain from doing something. For example, a judge might issue an injunction preventing a company from using a competitor's trademark until a certain lawsuit is resolved. 9. A subpoena. A subpoena is a legal document ordering someone to appear in court or to produce evidence. For example, in a criminal case, a witness can receive a subpoena compelling them to testify. Otherwise, they'd be held in contempt. A deposition. A deposition is a sworn, out-of-court testimony taken during the discovery phase of a litigation lawsuit. For example, a witness in a civil case might give a deposition answering questions from both parties, which can be used as evidence in court. 11. Discovery. Discovery is a pretrial phase in a lawsuit where both parties gather evidence. For instance, in a divorce case, discovery might involve exchanging financial records to determine asset division. 12. Tort. Tort is a wrongful act other than a breach of contract that causes harm and leads to private legal liability. Common torts include negligence, like in car accidents, or defamation or assault. 13. Negligence. Negligence is the failure to exercise reasonable care leading to harm. For example, if a property owner fails to repair a broken step and someone is injured, the property owner could be found negligent. 14. Breach of contract. A breach of contract occurs when one party fails to fulfill their obligations. For instance, if a contractor is hired to remodel a kitchen, but they don't complete the work, they might be in breach of contract. 15. Arbitration. Arbitration is a alternative dispute resolution, alternative to court proceedings, or going to court to settle things out, where a neutral third party, the arbitrator, makes a binding decision, sort of like a judge. It's to do things out of court and to not clog up the court systems. So, for instance, you might have a contract that might require arbitration instead of a lawsuit if there's a dispute, and you'd go through this arbitration process. Mediation is a voluntary process where a neutral third party, the mediator, helps disputing parties reach a settlement. Different from arbitration, mediation is not binding, and they just sort of help parties resolve a dispute. So for instance, a divorcing couple might choose mediation to reach an agreement on child custody or asset division. 17. Jurisdiction. Jurisdiction refers to the court's authority to hear a case. For example, a state court might have jurisdiction over family law matters, whereas a federal court handles cases involving federal law. Appeal. An appeal is a request for a higher court to review a lower court's decision. If a defendant loses a trial and believes there was a legal error, they might file an appeal to have the decision reconsidered. A plea bargain is an agreement in criminal cases where the defendant pleads guilty to a lesser charge in exchange for a reduced sentence. For instance, a defendant facing multiple charges may plead guilty to one charge to avoid trial on the others. Bail. Bail is money or property given to the court to ensure that the defendant appears in future court hearings. For example, if a bail is set at $5,000, the defendant has to come up with this $5,000 to be released from jail before trial so that they have an incentive to attend the trial and get their money back. Habeas corpus. Habeas corpus is a legal action that allows prisoners to challenge the legality of their detention. It translates to, in Latin, "you shall have the body," and it's used to prevent unlawful imprisonment. Probation is a sentence allowing offenders to remain in the community under supervision instead of serving time in prison. For instance, a first-time offender might be sentenced to probation instead of jail. An acquittal is a legal judgment that a defendant is not guilty of the charges. If a jury finds that there isn't enough evidence to prove guilt beyond a reasonable doubt, or the judge thinks so, the defendant is acquitted. Statutes of limitations. The statute of limitations is the time limit in which a legal action must be taken. For example, if someone wants to sue for personal injury, they might need to do so within 2 years of the incident, depending on the jurisdiction, or else it's too late. Finally, class action. A class action is a lawsuit filed by a group of people with similar claims. For example, if a defective product injures multiple people, they might file a class action against the manufacturer to seek compensation collectively.